Perfect. So now we head to our final closing panel of the day. And the closing panel of today addresses the legal overlaps and how they may hinder innovation. As AI continues to evolve, companies face increasing regulatory pressure to balance compliance with the technological advancements. Yeah, these frameworks are designed to protect privacy and ensure ethical AI development, but they can also create challenges for businesses trying to innovate. In this session, we'll explore whether these overlapping regulations are creating obstacles and how organizations can navigate them while driving progress. I am very happy to welcome our three panelists for the closing panel. First, I would like to welcome Raffaela Nicolazzi. She is Data Privacy and Consumer Protection Lead at OpenAI. Next, Professor Dr. Sebastian Schwamberger. He is Assistant Professor for Civil Law, Business Law and Digital Law at the University of Rostock. And last but not least, Dr. Axel Kessler, Head of Data Privacy at Siemens AG. I am very happy that you're all joining me at the closing panel at this year's Privacy Conference. Raffaela, I would like to start with one question for you. Tell us, where is OpenAI heading and what major developments have occurred in the recent weeks for you or OpenAI?
Fantastic. So first of all, thanks a lot, Isabel, for the invitation, for moderating this panel. Thanks a lot for also hosting us here in this virtual conference. Well, so I have to ask you how much time I have to answer this question, because I can speak about it for a few hours. We're all aware, right? There's a lot going on at OpenAI at the moment. But I think when it comes to AI, we're living a period in history that we have way more questions than answers. And right, this I think comes naturally with anxiety, frenzy about where AI is taking us. But I think what really fascinates me is how AI is advancing so quickly, right? And every day, basically, we learn new capabilities that AI tools can help us perform for us, right? Mm-hmm. And I think these advancements are not just enhancing our daily lives, but I think it's really paving the way for more scientific innovation, discoveries, efficiency, and much, much more. So the way that I see this being used is, as I said, in very extraordinary ways. And let me give a few examples, especially what we're seeing in Europe. And the first one I wanted to bring is a Danish startup called Be My Eyes. So they are helping more than 250 million people that have vision impairment to navigate the world, right? So they use GDPR to provide assistance. And personally, I have a friend who has recently rediscovered a vision impairment, and he managed to pick a flight, go to the airport because he used this app in his phone, something that he could not do it before, right? Or we can talk about Klarna, the Swedish fintech that is integrated ChatGPT to provide customer support that's diminishing efficiency, that something would take 11 minutes now takes 2. And also with the government. So the government Iceland is another example. They have partnered with OpenAI. They are preserving national language using GPT-4, also addressing concerns of language extinction. Albania is using OpenAI solutions to accelerate AU accession. So again, I think this fast pace of the technology really tells us one thing, that AGI is not going to come, AI is not going to come in a moment, that we arrive in time. We see this evolving in levels. And basically all that we've seen so far, we consider like a level 1, right? So these are the chatbots that we have that can understand language fluently, right? They can do isolated tasks. And then you asked me about the things that happened recently. So we recently launched OpenAI O1, which is not a new or larger model, but it reached the reasoner's level, right? So human level, problem solving, think for longer. And one was first of its kind on that type of tasks, outperforming even some PhD human examples. And just to conclude, I think as we move forward into these levels of AGI or the progress of AGI, the possibilities of innovation, progress are limitless. But I think with that advancement, of course, comes very big responsibilities. We're very much aware of that, right? So how to deploy and ensure AI is deployed and developed safely, ethically, and in a way that respect individuals' rights, particularly the right of privacy and data protection that we will discuss in depth here today. So again, having conversations like the ones we're having today is super helpful.
Yeah, thank you very much, Rafaela, for answering the first question. Now I would kind of jump to Mr. Kessler and ask you the question, in your view, what are the key components of effective AI governance maybe in your company, or what companies should focus on when implementing these technologies from your perspective?
Yeah, this is. I could also speak a little bit longer.
We all could.
That. But I mean, first of all, you need to know which role are you in. Yeah, like Rafaela would probably be in the provider position, and we as company, we would rather be in the deployer position. But what about adapting the AI application to your needs? Are you then growing into the provider position? So this, of course, then changes the whole picture. Interesting maybe for our audience is that I don't see a big difference between high risk and low risk applications, because you need to be, and these are the key components then, because you need to warrant transparency anyhow. You need to check the system, you need to test it. And not only in the beginning, you need to continuously test it. And if you do so, there will be funny results. Just play around with your HR tools a little bit, and you will get some results which will not be liked by our HR folks, because bias is in large language models, and therefore the results are also often biased. So you need to test it, continuously test it, give transparency, and test robustness of the system. So these are the key components. And maybe that's maybe that's a vague thesis to say it doesn't matter whether it's a high risk or a low risk application. I think you need to take this into account whenever you use AI applications.
Yeah, thank you very much. Professor Schwanberger, from your perspective, if we look at this, what Rafaela and Axel Kessler said, right? From an academic perspective, do you believe that there are legal overlaps between the current regulations, such as GDPR, AI Act, Data Act, and are these regulations maybe a threat to innovating technologies?
Yeah, thanks for having me, and thank you for the question. I think that legal overlaps will always appear, because it's about different schemes. We have the GDPR, but not only the GDPR and the Data Act that are overlapping with the AI Act. We especially also have copyright law, for example, text and data mining, which will overlap. And from my perspective, it's not necessarily the overlaps that could maybe threaten innovation, or regulation does not really always threaten innovation. It's more that this uncertainty with the current regulation, that we do not really know what AI is, that we do not really know how these legal acts overlap. I'm just taking the example of the GDPR and the Data Act and how this is regulated. And then also the AI Act, when we are looking at Article 22 GDPR and Article 86 AI Act, when it's on the right to explanation, where we don't know if this is already covered by the GDPR or it's covered by the AI Act. What I want to say is that the uncertainty and then the process, how legal acts are currently being published or currently being handled, and this uncertainty that the practitioners are struggling with and also we academics are struggling with, that's, in my point of view, a little challenging. And also the uncertainty between the legal acts, not only in Europe. I just said to Rafaela before that it's not only Europe. When you're training an AI model, you're taking data not only from Europe, but from around the world. And all these schemes work with each other, and they have differences between them. For example, in the US with the California Consumer Privacy Act, or in Japan with their Privacy Act, they are all a little different, and it's not really certain where these differences are or if they are this big as we think. So uncertainty is what I think threatens innovation.
Yeah, thank you very much. Rafaela, would you agree? Is there some kind of uncertainty, or if you could explain to us, how do you ensure compliance with all these privacy regulations within OpenAI, just to be able to continue to innovate the AI?
Yeah, absolutely. So I think there's a main premise when we talk about GDPR compliance and privacy laws around the world, right? I think we're always seeing some conversion in some of the key concerns out there. But before that, I think one of the main premises that we have to have in mind, and that's across the whole industry of how all of these AI models have been developed, is that the ability to provide this transformative and helpful AGI to everyone is really rooted in developing AI systems that are built in vast and diverse data sets, right? So we want AI models to learn from as many languages, cultures, subjects, industry as possible, right? So they can be helpful and benefit as many people as possible. So basically, the more diverse a data set is, right, the more diverse models' knowledge is exposed to, understanding language there is, like a person, right, who travels and is exposed to different cultures and countries, the more people and countries AI can safely serve. So to me, the question actually is how to strike the right balance between safeguarding all this data throughout every stage of the model to the development while innovating it, right? And for us at OpenAI, it means building AI responsibly in three main things, with three key main pillars. So one is enhancing transparency. Second is users controls. And third would be, of course, reducing the processing of data, of personal data, right? So number one, very quick. So we are one of the companies in leadership on transparency. So an example, when we launched in 2029 GPT-2, we published technical papers. We published a model card that discussed in details how OpenAI used publicly available data for training the model. And all those publications are meant to empower users, the public in general, with clear information about the models. Second one, giving users control over the data. So providing users with this access controls, easily access controls over their data, so offering options like data preferences in controls to manage where data, their chats are used for model training or exporting, reviewing data or deleting data. All of this, like having a privacy center which users can easily access and exercise their rights, right? And third but not least, as I mentioned, is reducing the process of personal data from start to finish, right? So implementing a series of privacy protective measures like data filtering to reduce personal information from the training set in the post-training, and then of course reject requests that would provide private or sensitive information. One thing as well in that point, that doesn't mean that the work is done, right? I think to the contrary, back to my first point, that AGI is evolving super fast and super challenging for us to keep up with the pace. That journey will not come without any challenges. And I could speak about challenges around regulatory dialogue, overlaps, as Professor Sebastian mentioned, the need for common standards across the EU. But again, to me, I will reiterate that point, that the main challenge will be to keep up with the pace of this AI evolution, which it translates as interactive deployments. And also, I think, learning from real use, so that we can better and improve the model as people are understanding what's happening in front of them.
Yeah, thank you very much, Professor Schwamberger. Rafaela talked about the necessary diverse data set. Do you foresee conflicts between the GDPR and the Data Act when it comes to ensuring privacy in AI technologies? And if you see so, how can we resolve these conflicts?
Yeah, I mean, I mean, I see several conflicts, and I'm just picking out the two major ones. The first one is the legal ground for the processing, where we are all struggling a little, which is, I mean, you can either base it on consent, where this is also something that's discussed in Japan, that when you put data online and it's publicly available, that you consent to the processing, or the publicly available data could not even be within the scope of the data protection law, like it is in the US, or it's like in Europe, where you have legal ground when it's put online and it's publicly available. But what we are struggling with is that these two regulations, also the US and also the European one, is based on that the data subject himself puts the data online. And that's one thing that they are all struggling with, because how can I know if a person has put this data online by himself? So that's the first issue that we are struggling with, and how we or all the companies can comply with. The second one, and this is a little bigger, is what should you do when your model is or contains personal data, and if a person wants to have its data erased or has its right to be forgotten. And if you can't extract this data alone from the model, because it's the model itself, the model is able to remember, and how you're dealing with that. So here we are currently discussing on if we do not need a little opener approach on the right to erasure, because it would it will kill the innovation that went into this model if you have to erase it, because it contains personal data and the model is able to remember it. So that's what we are currently discussing in academia, how we are going with the legal grounds for the processing of the data. That's something that will be or can be solved within the current legal framework, but what's more urgent is how are you going to do, or how we're going to erase personal data, and what happens if you can't erase it, because it will not be sustainable if you don't keep up with a model, if you have to delete the model and develop it again. I mean, I think that's all clear to us.
Yeah, Mr. Kessler, are you also struggling with these aspects Professor Schwamberger just mentioned, or maybe as a first point, and as a second point, how does Siemens integrate AI governance into existing compliance frameworks, such as data privacy regulations that are already existing? And do you have special, are you combining them in a way? Oh, you're on mute.
Yes, thanks. So I start with our governance efforts, let's say. So in the beginning, we didn't know how to implement all these provisions. And I mean, it relates a little bit with data privacy, but really the topic is different. And if it's more about technology and robustness and okay, some are a bit parallel, but then when we talked about how could we implement all that, we saw that this is very close to our data privacy by design principles. So when we try to develop a tool, we also need to look at it from a data privacy side at an early stage. And now we said we simply include the AI requirements in that milestone at a very early stage. And so this is currently what we are discussing. And I think this is feasible. We are not really happy with including, the AI Act is so broad. Yeah, it covers with this reference to Annex 1, to the machinery directive, or to these medical devices. It covers so much more things. And if you look at the conformity assessment, where all this needs to be done, a conformity assessment lasts around 2 years in our house. And so we just talked about some uncertainties. So if we still have some uncertainties and then add the 2 years period, I think we will really struggle with that. And that was why we were not really happy with this broad scope of the AI Act, and said basically, come on, let's leave out all this reference to all these other EU regulations, because we really know what we're doing for years. It's AI is something we're doing for decades already. I mean, our computer tomographs in the hospital, they know what they do. They simply compare things they learned in the past already. So it's very similar. And now all of a sudden we need to add certain aspects to it. And we simply say that this is not necessary. We could have done otherwise better. So partly we are happy with the EU AI Act, especially when it comes to Gen AI things, really new things. But I think with the old things like the machinery directive and stuff, I think that was a bit too burdensome for the companies, and it will hinder our innovation because it slows us down.
Yeah, thank you very much, Rafaela. As Mr. Kessler said, it's important to look at new regulations at an early stage. Do you at OpenAI also, or how do you plan to handle the practical challenges that are coming up with new regulations? Maybe there are new regulations coming someday we don't know about yet. And are you also trying to establish certain things in an early stage at OpenAI?
Yeah, I mean, I think uncertainty is a constant in the life of any privacy data practitioner currently, right? Which is also something that makes me feel excited about what's coming ahead. And I also share, I think, the views of Professor Sebastian, right? That the legal overlaps will always exist, right? One thing to note, though, is that the goals of the both AI Act and GDPR are very aligned with the mission of OpenAI, which is to develop safe and useful AI. On the AI Act specifically, I think many of the practices mandated by the Act are not new to us and are aligned with our mission and the expertise we've built in safety and security. Right? At the same time, there are certain specific requirements, like in general purpose AI applications, they're still unknown and will be specified, as we know, over the coming months. Yeah. We do have already dedicated teams that are looking to that will make sure that our policies and practices will align with the requirements that will come in. And also one thing as well that I think it's quite important to note here as we understand and learn how to interpret this in practice is that it should be grounded in science and reflect the current state of the art of the field of AI, right? So these companies in general, most of them operate globally, right? We think AI Act also should think about align with global standards whenever possible, of course, in order to avoid any type of fragmentation that would be unhelpful, right? Especially on the governance landscape and the multiplication of redundant frameworks. On the privacy laws specifically, I think as well it's important to note that we're doing a lot of work, collaborating, engaging with privacy regulators, sharing our knowledge and expertise, hearing and implementing feedback from constructive dialogues. And also, right, GDPR doesn't come in a vacuum, right? It is a technology neutral regulation. So the challenge now are basically how to interpret the specific provisions in light of these new capabilities, right? That's why we also commend the work that's been done by many DPAs across Europe to have public guidance, public consultation on guidance that they are issuing to really have an informed debate about it. And as well, not to mention that I spoke about the international alignment, but also, I mean, within the bloc, right, within the EU, we need to see that harmonization as well. That's why regulatory dialogue will be key to get that right. An example, right, is the EDPD guidance that we are expecting on the legal basis for model training. So just one on that. So yeah, let me stop here.
Thank you very much. Maybe Professor Schwamberger, you can jump on that point. Do you think that the current regulations on privacy, especially the GDPR, needs to be reformed in a way to be capable of the new developments in AI, or do you think that we're completely fine with how it is and we just have to wait, as Rafaela said, what we're going to get in the next weeks, months, years, and then we'll see?
Yeah, no, I mean that's a pretty difficult question because when I look what I did the last 2 years, I read a lot of legal acts and I read hundreds of pages, and I'm at the moment happy that I have a kind of overview on what there is, but I don't have on the exact wording of each act, and neither does academia or any comments. And what I'm struggling with is when you at the moment you don't know what some provisions actually mean and if they are working in practice, and when you're starting to regulate again, because at the moment no matter if you're talking academia or if you're talking to practitioners, there's a lot of new legal acts that we have to work with. I think it's kind of a lot, but it's manageable at least to some point. But I would not start again to regulate every new technology that there is on the market, only when it's really clear that something is not working. But I think when I take this example of the right to erasure, I think we need a debate on how are we standing to innovation in Europe, and what is more important. How important is the right to privacy, and how important is innovation for us? Because when the right to erasure leads to the erasure of a whole model, then it will certainly be privacy that will be on top of innovation. And I don't know if we want to have this at the current state where we are, but we need to discuss it, and it's a discussion in the society we need to have on how is the role of innovation in our Europe, and how can we have a competition with the US, for example.
Yeah, thank you very much. Mr. Kessler, would you agree, or do you see other aspects from your perspective?
Yeah, no, it is true that research is going away from Europe to the US in Asia, because we can simply do it there faster and with less costs. The simple act of anonymization of data takes away so much data from our data set, and it involves costs, time, and we lose a bit of the data, and therefore, of course, our business says, so let's do it in China or in the US then, and it is as simple as it is. So I'm really pressing. I think this erasure topic is a valid one for us. From a business side, this pseudonymization and anonymization should really be a lot simpler. And just think about video surveillance in certain areas. For example, in trains, if we try to blur all the people, still it is regarded as pseudonymized data instead of anonymized data, and we still cannot we can use it, but not to an extent we would like to. And the same is for the car manufacturers, a big topic. They drive around and take pictures, and it is still within the data privacy arena, although the data is really blurred and you cannot really recognize someone. And it would be just simpler if we have if we make it a bit simpler for the companies to use these data sets.
So you do think that at least you as a company do need more guidance in a way to look into the future?
Yeah, more guidance, but the guidance should then really be also business friendly, and and don't take the worst assumption. And of course, it's like Sebastian said, it's a bit of a balance and a political question then. What are we willing to take? But if we see these days that research is going to the US and to Asia, and one day maybe they get better medication in such countries because it's used with their data sets in such countries with their ethnical groups, and which better applies to them than to the European population.
Yeah, maybe I can just ask you one other question. In your experience, do you have best practices that companies can adopt to ensure that their AI initiatives are not only compliant, as we talked about, but are also ethical and transparent?
Yeah. So we for a while we were really doing a lot of ethical work. So because we made some bad experience in that area, to involve our ethical view at a very late stage, or it was too late. So we try to discuss ethical points already at an early stage. There's not a yes or no about ethical viewpoints. It's more we need to include it in our discussion and see whether we really want to do it or not. And it also depends then whether you want to roll out a certain system in Europe or elsewhere. That also matters a lot with our products. And so we include stakeholders from various disciplines in our house, and the ethical group is one of them. It's very close to my artificial intelligence working group. And so we also include the Workers' Council, for example, when it comes to the usage of AI by our workforce. I think it's important to include such stakeholders at an early stage, so that you don't get any obstacles at a very late stage.
Yeah, thank you very much. As we're running a bit out of time, before I come to my closing question, we do have a question from the audience, and I suppose it's for Rafaela because it's about OpenAI. I'll just read it for you. How does OpenAI ensure that personal data is either not ending up in models or can be removed within the legal time frame of a data subject right request? If possible, also elaborate on a technical level.
Yeah, absolutely. I would need way more than 5 minutes to answer this question. I'm happy to follow up with that person. I can't see the questions here in my screen.
Yeah.
But I think, as I said in the beginning, right, we all should acknowledge the fact that to develop these models, you need a vast data set in order to make it helpful and useful. It is also true that in order for the model to not use or not regurgitate personal data, it needs to know what it is. So there is an incidental part of it that has to be, so it knows, so it learns what it is, so it doesn't regurgitate that, right? So even though we're not, tracking or like going through this particular data sets that may have personal data, the reality is that it needs some component of it in the model phase, in the training phase, so it learns what it is. So then, to the second point about kind of like the output, when an individual is writing a prompt, is not satisfied with the answer they get, at OpenAI we have something called the Privacy Center that every individual can go there and request any type of data set rights, including the right to opt out. So I encourage that person that made the question to take a look into that. And yeah, so let me stop here in the use of time.
Yeah, thank you very much. We still have 2 minutes left, so I would just ask you all one last question, and maybe a short answer. What must we do to ensure Europe becomes a global leader in AI and data-driven technologies? Maybe, Mr. Kessler, you want to start?
I think we should really look also to the US and other countries, how they do it. So maybe we have an aligned approach. And we are not, that not some providers simply leave Europe out of their innovational cycle.
Thank you. Professor Schwamberger?
Yeah, I think we already heard it today from the European Commission that the GDPR, for example, is based on a risk-based approach, and the same is with the AI Act. And I think we should rather focus on this risk-based approach and focus on very small risk that should also be small hurdles for being on the market. And I think that's a way forward than focusing on this risk-based approach.
Rafaela, you've got the last word.
Yeah, so I mean, directly to your question, I think it's definitely like adoption of AI at a scale as quick as possible, right? As we heard, we're already seeing a rapid uptake in the US among consumers and businesses. That's also a concern that we saw in the Drivers Report, right? Where they noted that there's lower productivity growth in Europe compared to the US and other regions. So I think it suggests that, any type of EU policy framework should enable and stimulate AI use, rather than just layering complexity on requirements. And I think on top of what Professor Sebastian mentioned, there should be acknowledgement on accountability from companies as well on how to address risk-based approach with also accountability.
Perfect. Thank you very much to you three. We're perfectly on time. So thank you very much for participating in our closing panel at the Privacy Conference 2024, and have a nice day and evening.
Thank you very much.
Perfect. So that brings us to the end of the second day of this year's privacy conference. We've heard a range of inspiring discussions today, from the evolving regulatory landscape and the challenges of AI governance to the balance between privacy, ethics, and innovation, as we just heard. As we move forward, it's clear that collaboration between industry, regulators, and innovators will be key to shaping the future of privacy and technology. Of course, we had a lot of questions today. I think that most of them we had the time to answer, but feel free to post your questions on the platform, and hopefully you will get an answer. Yeah, dear participants, I hope you all enjoyed our topics we covered today, and thank you for your participation in today's engaging discussions. Thank you once again to all our wonderful partners at this year's privacy conference, and for making this conference possible and making it free for charge for you all. Thank you to Data and More, Legitimus, Microsoft, Cloudflare, Google, Meta, Coeo, Grey Swan, Graf von Westfalen, Keatos, Pils Legal, and TikTok. A big thank you to all of our over 50 speakers yesterday and today, all our panelists, and of course to you, the audience, for being part of these conversations. Many thanks also to the wonderful Bitkom team in front and behind of the camera. Without this team, this conference wouldn't have been possible. Thank you to Robin, Sarah, Alla, Alice, Kevin, Josie, Maya, Martin, Bennett, Orly, Lennart, Ellen, Paul, Lina, Maxi, Megan, and Stefan. I hope I didn't forget anyone. And a big thank you also to my co-moderators today, to Professor Markus Helfrich and my colleague Patrick. Thank you very much, and we look forward to welcoming you at the Privacy Conference 2025 next year. Have a nice evening.